Hi, everyone. I'm Maggie McGrath, editor of Forbes Women. On Monday, the Supreme Court decided not to intervene in a case in Texas that allows the state to deny emergency abortions to patients who may need emergency care. Joining me now to break down this decision and what it means for people on the ground in Texas is Harry Nelson. He's a healthcare lawyer and the founder of Nelson Hardiman. Harry, thank you so much for being here.
Thanks for having me on, Maggie.
All right. I just gave a very high level and simplistic summary of what happened today, but can you explain what the Supreme Court did today?
Sure. So essentially, the Supreme Court elected not to intervene in a Texas case where a lower court had said that hospitals in Texas do not need to provide emergency abortions, even in life-threatening situations. The case really presented a conflict between Texas law, which has a extremely limited exception for abortions to be performed to save the life of a mother, and the federal emergency medicine law, the Emergency Medicine Treatment and Labor Act, EMTALA. And so, I think many observers assumed that federal law would take precedence. We have a principle that federal law is supreme when it comes to conflicts between federal and state law, and that that EMTALA would require the hospital and hospitals around the country to provide emergency care to a woman whose life was threatened, even if the necessary care was an abortion. And the Supreme Court today said no, it was going to let the Texas court decision stand, and which essentially allowed this hospital not to provide an emergency abortion.
It's a kind of remarkable decision given what we've seen over the summer and early fall. We've seen women lose their lives because they haven't been able to access care, particularly the mother in Georgia who lost her life just a few weeks ago. And then also there was the case in Idaho, which longtime or even short-time viewers will remember. EMTALA was at the heart of another Supreme Court decision involving Idaho state law. So how is it that the court decided this today when their decision in June around Idaho and the application of EMTALA there was actually different?
Yeah, it's very interesting. A lot of people were caught off guard by this. In the Idaho case, there was a strict ban on abortion. And so in that case, the federal court said that no, EMTALA takes precedence over Idaho's law and protects physicians from being prosecuted under Idaho law when they perform abortions that are necessary to stabilize the health of a patient. And in this case, Texas law was slightly different. It does have an exception to save the life of a mother when the risk to the mother's health is severe and imminent. But the problem is that hospitals and doctors in Texas have been complaining that that language about severe and imminent risk is vague. They've asked the medical board in Texas to clarify it, and the medical board has refused to clarify it. And so the Supreme Court said that it was up to Texas courts to decide, and that in this case there was that difference between a law that allowed for zero abortion versus a law that had a very, very limited and vague exception was enough to let state law take precedence, and to mean that EMTALA does not require hospitals to perform abortions in situations like this. So it's very scary, scary for women whose lives are at risk, scary for healthcare providers who are now presented with a square conflict of the law and their ethical responsibilities between following the federal law requiring them to provide emergency care and the Texas law preventing them from providing abortions in almost every case.
But it's that almost that gave, I guess, the wiggle room, right? So now it's up to doctors in Texas to determine when a woman's life is really at risk. And is this a situation where we might see them let a case go longer than they would otherwise to really ensure that they are operating according to Texas law, although maybe not the way that HIPAA would have them operating?
Yeah, I think we're already seeing a lot of data that this language about severe and imminent risk to the health of a pregnant woman is causing doctors and hospitals to be conservative and not provide care in situations that look and feel like emergencies, where there are potentially fatal consequences and serious health risks to pregnant women. So it is, this is absolutely creating a danger, and is a situation which we have to imagine is going to require more clarification and attention ahead.
I was going to say, from your position as a lawyer, do you foresee further litigation here? Because just as someone who has doctors in her family who care about patient care and outcomes, it feels like this is not the end of this issue.
Yeah, I think you're right. I do think this case is going to set a precedent for other states that have strict abortion laws to also seek to limit the power of federal law under EMTALA. And we're likely to see more challenges expanding the legal uncertainty for healthcare providers nationally. So I think this is signaling that we are just at the beginning of yet another stream of abortion-related cases that is going to preoccupy us for years to come.
For years to come. But there is a presidential election in just a month. Could a future Harris administration do something to tamp down on the number of challenges to EMTALA, or are we looking at these challenges no matter what?
I mean, it's possible certainly that the federal government could provide a clarification amendment to EMTALA to specifically clarify this issue, assuming that there was a requisite majority in the House and the Senate. That would certainly solve the problem. It certainly looks like, to the extent this is in the hands of the court, we are in sort of a very in a toss-up where there's going to be a lot of deference to restrictive state laws.
Does this have implications for other kinds of emergency care, or does today's Supreme Court decision really only, and I use only in air quotes, affect pregnant people who are in an emergency situation?
I think it's a great point. I think this case does have a significant potential impact in public health, far beyond abortion, in essentially suggesting that that the federal EMTALA law, which by the way was the result of a case in which a hospital refused to provide care to a pregnant woman years ago. That law is going to the ability of states to restrict care is the more power that is given to that is going to essentially broaden public health risks potentially in all kind of unforeseen areas. So I do think that this case will have public health ramifications for emergency care. It is likely that it will embolden states and embolden hospitals to take more strident positions and to not be quite so protective. It's certainly a kind of a dark potential implication of this case.
Does it have implications for the Senate race in Texas? Because abortion is at the center of not just the presidential election, but Senator Ted Cruz's campaign for re-election and his opponent, Colin Allred. It has been a subject that he has brought up again and again and again. Do you see political implications here, not just for Harris versus Trump, but the senatorial candidates in Texas?
I do think that's certainly on the table. I think that Texas has, and a lot of Texas politicians, like Senator Cruz, have tried to argue that there is an exception in the law, and that is offering some balance, that it's not a total ban. But what we've seen from this case is that when the law is written so strictly and with this language of severe and imminent risk to the life of the mother, that all those kind of waffle words are really making this effectively a ban on pretty much all abortions. So I do think this case and the attention paid to the very ineffective exception that's in Texas law is going to give more people pause about whether Texas has gone too far, and I think we're going to see that play out in November.
Are there other pieces of litigation that you are watching right now? I believe at the end of the week, there's a case involving North Dakota abortion law, but what else is on your radar?
Yeah, this conflict, basically since the Dobbs decision repealed Roe v. Wade, we've been looking at this, at the whole series of state versus federal conflicts in terms of how far states can go. There's a handful of other cases We're seeing a number of abortion restrictive interest groups that are advancing cases, and in a whole series of places. We're certainly paying attention to the referenda coming up. So there's not one sort of burning case right now, but I would say 7 or 8 situations around the country that we're just watching and monitoring to see where the next sort of bombshell is going to be.
And is there anything that we, the public, we, the media, are not paying attention to that we should be, that you see from your seat as an attorney that we might not see from our seats as journalists and lay people?
I think that this question of the implications of federal state supremacy and where that has other implications in terms of things like food and drug law, and in areas far from reproductive health rights, is a really sort of concerning question that people should be paying more attention to. I think the Supreme Court's decision here has potentially far-ranging empowerment of states to override long-established federal standards and to really complicate the way that not only healthcare but drugs, medications, and all kinds of other activities are supervised in this country. So that's certainly one thing I'd be paying attention to.
That is a sobering warning, Harry. Thank you so much for joining us and breaking this down today. We so appreciate your time, and we'll have to have you back the next time there is a Supreme Court decision on reproductive health.
My pleasure. All right, thanks.